We are happy that the match is concluded.
Thank you.
This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Give you 5 minutes.
Just 5 minutes, not more than that. Because your Lordship knows because the domain and the jurisdictions are entirely different. Your Lordships have seen that. The entries are different, domains are different. They can deal with their employees, we can deal with our employees. Right? So that's one part of it. 2, if they were to pass a law saying accept the DNS allowance as discovered by us, it would be unconstitutional because that would be encroaching upon our freedom. Right? So their entitlement is valid, but entitlement qua our notification. No doubt. They can't ask for beyond the notification. Now they are interpreting the notification in a manner to suggest that we have accepted the DNS allowance as well as decided by the central government. That's the case. But our intention, we have reflected on affidavit that that's not what we want. Whereas our intention cannot be interpreted through a judicial decision making. No, this was not your intention. When we are saying it was our intention, and we have demonstrated that, then its impact on states. This is not a matter that will be decided by us. Existing emoluments is defined in several states where they are giving much less, including Himachal and other states, right? And those who are not defining existing emoluments, even they are giving less. So any decision by your Lordships that what is decided in terms of the DNS allowance will apply to all states will have impact throughout So therefore, it is my humble request if your Lordships are even inclined to do that, then your Lordships must issue notice to all states, because then it can't possibly be that we are forced to accept DA decided by the union government, as well as the rest of the states will not have to follow that. Yes. That's number one. The second argument is, your Lordship knows that the genesis of this is under the industrial law. What used to happen was that an industry would have 3-4 regional offices, North India, South India, Western India. And whereas the argument dispute used to be raised as to whether this DNS allowance should apply to other regions at all. And your Lordships have said that DA is to be decided region by region. Why? Nature of inflation is different. Nature of the habits are different. Cost of living is different. Cost of living is different. What profits that particular unit makes in Ranchi would be different from the profit he makes somewhere else. So therefore, that has to be decided on region by region basis. Cost of living, purchasing power of the individual, what other benefits those people get, workers get apart from this, which are not given by the central government. So there is it's not just finance, there is a complexity of issues. So please leave it to the state government. Don't go by this step, because the existing emoluments were decided there had to be a base year, and therefore everything that is said by the central government must be applied to us. That's all. Thank you. I'm sorry,
With deepest of respect,
just 1 minute. My learned friend relied on Article 309 so as to suggest in a manner of speaking that if there is any kind of a vacuum in terms of the rules, then that will have to be decided by the governor under 309. What I wish to point out is your Lordships are aware of Article 162, where the executive power of the government is coexisting with the legislative power. So if today you have the legislative power under 162, you can always issue a notification, unless, my lords, it violates the statute. And it's no one's case that the notifications violate the statutes. The notifications are not understood. The other aspect that is sought to be urged, really is that we were earlier following central government rates. That nothing can be further from the truth. Up to 2010, the rates that were adopted, let's say suppose the central government had a particular rate in 2006, I adopted that in 2009. I have never followed central government. So therefore, those instances we can give a note also clarifying that. We clarified that earlier in our pleading. You have already that we have never followed central government.
All clarifications are made, that 3 review petitions are taken from different time to time. The issue is not that the center is directing.
How much time it will take, sir?
Well, I just finished within 10 minutes. The issue is the entitlement of DA in terms of the statutory rules of the particular state. The rules of state of West Bengal is not going to govern the state of Chhattisgarh. These are all wrong conception. Now, all these issues were considered by the tribunal. Kindly, will not come to page 482, paragraph 30. What is the defense of the state? The rule makers have understood the rules in a particular way and they have followed it till 2010. Now, suddenly after 2010, they wanted to divert. Whether the diversion was at all reasonable according to rules and according to the state government's attitude towards the employees. And kindly, when I just read out paragraph 30 of the judgment of the tribunal, it was upheld by the division bench. On review, that was also again upheld. Here, Millard says what norms, principles have been followed by the state government for release of DA for its employees. No satisfactory answer in this regard came from Mr. Basu, learned counsel representing the state respondents. Mr. Basu has merely tried to impress upon us that the state government has followed the pattern of central government releasing DA to its employees. But the state government could not pay DA at the rate and from the date paid by the central government to its employees due to lack of financial resources of state government. This is the stand. Rule makers appreciated how the rule is to be interpreted. They were not by the brilliance of the councils. Okay. And then the tribunal says, we do not say that you have to follow the central government. We say you follow your own rules and formulate accordingly. Now, kindly come to now paragraph 31. We have already observed that the payload.
Read, Mr.
I did not read. I just.
Submissions that what you are saying.
I say that
is there something new which you wish to add?
Nothing. I have no substantial legal argument has been advanced by a subsequent attempt. This is a repetition of the whole things. And they have to follow their own rules. Tribunal has directed the chief secretary, you formulate. Why did they formulate? So this is simple.
Thank you. Anyone else this side? Thank you.
Sir, I am just stepping into the shoes of Mr. Gopal Subramanian. The written submissions on his behalf are there. I'll just hand it over. And additionally, there are some rules that we wish to place. There are copies of the rules that we would like to show. Just one submission that I'm not reading out anything. Just one submission that the entitlement flows from the service rules that the employees have. And the entitlement rules, entitlement is under the West Bengal service rules of 1971. That compilation of rules we have provided. Rule 93 of the service rules indicate.
Our request to all of you is whatever you are handing us to in court, you have to e-file it, please.
Please, we'll be e-filing it, and as well as with physical copies. With the registry, we'll ensure that.
Please.
So it's there on my lordship's file.
Yes.
May I go back to that is Bachar's?
One more, sir. Pleasure, please.
Sorry.
Yes.
Rule 93 of the compilation rules, the rules which we have brought up.
Which page?
Yes. This is page 74, internal at the bottom, page 70.
We don't have it.
We'll just give it. May I have page 74? Flagged at the top.
Yes.
74 minutes. Rule 93 minutes. A government employee shall be entitled to be paid while on joining time minutes. Clause A. Under Clause A of Rule 50, the pay which would have gone had he not been transferred. He will also be entitled to dearness allowance, if any, appropriate to the joining time pay.
This is my entitlement.
So, the rules itself provide my entitlement that I am entitled to the rules. I am entitled to the dearness allowance rules. And it is not the memorandums rules. That is what we would like to clarify. And the rules having been accepted in 2006, 1/1/2006 date has been triggered off, on which date AICPI has been accepted.
Yes.
Now, the rules clearly say that the formula which is there, your lordships have seen that, page 103, AICPI formula has been brought out. Therefore, it is implied and very clear that it will be the formula as per the AICPI. Now, that formula cannot be static. It has to change.
No, where are you reading the formula?
In the paper book. 103 of the paper book, your lordships have seen the ROPA rules. Existing anomalous. From here, I was only indicating page 74. The lordships have marked. This is rule 93.
Okay.
On the basis of rule 93, I am only indicating that the service rule provides that I am entitled to the assets. 103 of the ROPA rules talks of AICPI, the formula which is there, and it is not a static one. Therefore, with changing times, the formula will have to be applied. On the day it was applied, the emoluments and the salaries that we were getting were at par, and therefore it was at zero level. And thereafter, it has kept on increasing, and therefore the formula will have to apply with time. It cannot remain a fixed thing. If that is the broad news, otherwise, we've given the written submissions to us.
Only one point I need to address in rejoinder. Mr. Diwan actually gave a rejoinder note, which is a note common to everybody, or it is only for Mr. Diwan. Two things which he primarily said was that no mandamus can be issued unless there is an entitlement and public duty is one. Second, what my learned friend just preceding me also wanted to impress, he said that these ROPA rules only provide a statutory framework for revision of pay structure. It does not create any entitlement for payment of any allowance, let alone DA, and it cannot be pegged to an index. This is what they are saying, that it was a one time and there is no question of any index. However, there is a very fundamental flaw in this. In the first round, your lordship is aware that this is the second round. The tribunal first held against us. We went to the High Court.
Yes, please.
In the first round, at page 375, that is the judgment, that is the relevant part of the judgment which is rendered by the High Court in the first round, against which they filed a review. Review got rejected. There was no appeal. Your lordship may only note page 374, 75, para 24. I will read to your lordships, in fact, if your lordship has the second volume, precisely the same argument raised by the learned Advocate General and rejected.
In the first round?
Correct.
We are aware of it.
Then it says, apart from the fact that...
We have heard it. We have heard this.
Yes, your lordship is aware. It says, Mr. Kishore Datta, learned Advocate General, according to him, the findings of the tribunal that the claim of dearness allowance was not based on any legally enforceable right. According to him, the pre-revised scale of pay of the government employees has been transformed into band scale. According to the learned Advocate General, after initial fixation of pay under the ROPA rule, no formula exists for fixation of payment for the subsequent period. So what he said was, rule only, what Mr. Diwan also argued was one-time fixation. There is no question of any further revision. This argument is considered in great detail. I had referred to that judgment. How does the consideration starts first by noticing the relationship between the employees, then noticing the concept of what dearness allowance is.
We appreciate that. Mr. Patwalia, can we just request one thing? Other than this, anything which you wish to add?
No, other than this, what I wish to say is that in the initial written argument which they filed,
in fact, what we are going to suggest to each one of you is this, that there are so many,
we should consolidate because writing judgment, your lordship will need that also.
Comprehensive submissions, first to be filed by the petitioners and then to be responded by the respondents.
Yes. Let us give a final submission of what we are saying
exactly.
in one.
That's what we can. So you will file it in how much time? That's all, Mr. Patwalia.
There is nothing much, your Lordship. I've heard it for so long now. If I say something,
How much time?
but not only one point I've been asked repeated and validly so. In the opening submissions which they gave, the state of West Bengal, they gave a common submission. Now there, now their written submission has turned on the head.
It's all right. What we do, whatever they want to say, whatever, it doesn't matter. Let them, we can't stop them from saying they have right to say also. Mr. Singhvi, would you like to also address us on this issue? Yes, Mr. Singhvi. Please unmute him.
No, Malas, I think, Malas, we have taken enough time, Your Lordships.
Thank you.
Covered most of the points. I don't want to add to that. Otherwise.
And your Lordships have noted his presence, which is most important.
As if it's not important for Mr. Patwalia.
Here today only to say nothing more to say. We have heard. Thank you. We have heard Mr. Sibbal, Mr. Singhi, Mr. Ahmadi. I'm sorry, ma'am. What's your good name? Just give it in writing so that I don't commit a mistake. Add her name also. As also for the on behalf of the petitioner and also Ms. Kamal, Ms. Patwalia, सबका नाम लिख दीजिएगा. The respondents. We request the petitioners to file comprehensive. It is suggested on behalf of the Learned Council that let the parties file comprehensive written submissions. We agree with the same. Let the petitioners file written submissions comprehensive in nature, dealing with all aspects argued before us within a period of dash.
Next month,
whatever it is, 2 weeks. The respondents respond to the state within a period of 2 weeks. 1 week.
There are so many of us. Let there be 2 weeks if some intercede. Or like 1 week is also enough. 1 week is enough. 1 week is enough.
1 week.
One request that nothing new should be said now.
we are happy that the battle is concluded.
Thank you. Thank you.
It's so brilliant.
You said you can submit rejoinder written submission.
Yes, sir.
Thank you. So very kind of you.
Deeply obliged.